May I have your attention, please? Oh, good man. Thank you very much. Appreciate it. We're going to begin the presentation of our presidential address momentarily. Before that, I do have a brief announcement. My name is Rich Block. During the course of the morning, a number of you have conveyed congratulations and condolences on my appointment as the new editor of our proceedings. This is a job that requires skill, judgment, and substantial academic and editorial prowess. It should be self-evident, therefore, that I am not the appointee. The new editor is Professor Richard N. Block of Michigan State University, who is endowed in spades with all those essential requisites. I'm flattered by those who conveyed their heartfelt, if misguided, wishes, and who will now collapse in relief that the job of our proceedings is in truly competent hands. And now to the matter at issue. Jim Oldham's ascension to president of this organization has led me to do some serious introspection. We've been friends for some 40 years, and as I think about it, I can't figure out why. There are no two people in this academy who are less alike in every respect. For example, Jim has hair, lots of it. He is a big deal academic, an intellectual. He has a chair. I have a stool. Jim is the St. Thomas More Professor of Law and Legal History at Georgetown Law School. Seriously, Jim. Thomas More. The guy burned Martin Luther's books, refused to recognize Henry VIII as the head of the Anglican Church just because he ditched that bitch Catherine. Got himself tried for treason and beheaded. A mazel tov. Speaking of England, I was drawn to Jim when we first met because I knew he taught labor law and arbitrated. Now that's stuff all of us in this room can warm up to. Real people, real problems, frontier justice. You can imagine my distress and horror when I picked up some of the page turners James writes in his spare time. Would you get a load of this? The indispensability of manuscript case notes to 18th century barristers and judges. Lord Mansfield, stare decisis, and the ratio decidendi. That answered a lot of my questions. Reports of cases in the Court of Exchequer in the time of King Charles I. There's a book that was just crying to be read. All this Anglo immersion has left an indelible impression. You will note when Jim delivers his paper today, he will occasionally lapse into a kind of quasi-British accent, which is perfectly understandable for a guy from Muskogee, Oklahoma. Over the years, I've been privileged to join Jim from time to time in teaching courses at Georgetown. We split up the responsibilities. Jim took care of the substance, and I interpreted. I've generally relished my close association with Jim. We run and walk, we confide and decide and commiserate. Understand there have been times when my zeal for such collegiality was challenged. There was the day I called to get Jim's take on a troublesome just cause question. Jim was signing off on his 2-volume, 1,700-page treatise on English common law in the age of Mansfield. I was just putting the final touches on a case about a guy who hit his foreman in the head with a pickaxe. 5 pages. But Jim's 2-volume life achievement stays with me by my bedside. I haven't yet quite finished it, but I'm making progress. In fact, I want to read you the most memorable quote that I've come to thus far. Copyright 1992. Jim has salvaged some modicum of respect for himself by serving as permanent arbitrator for numerous companies and unions in steel, aluminum, or as Jim says, aluminium, transit, auto, professional sports, including Major League Baseball, football, and hockey. In hockey, Jim is currently the special appeals arbitrator for cases of players suspended for 6 games or more. He's never heard one of those cases, most likely because there's only one player in NHL history who ever received a 6-game suspension. He was a serial killer from Moose Jaw, Saskatchewan, who single-handedly burned and pillaged a mid-sized village in Nova Scotia. He got 6 games. Jim has a twin brother, John, who became a psychiatrist, probably in self-defense, and another physician brother, Newland, whose profoundly British name Jim has always coveted. Jim and Dibby have 2 children, Nelson, a restaurateur in Carbondale, Colorado, who was a member of the United States Whitewater Kayak Team, and Sarah, a physician with a great sense of humor. That's actually scary. I'm thinking Sarah's a doctor I'm not going to trust with a rubber glove. Dibby herself is a funny, gorgeous, powerhouse commercial real estate mortgage banker in Washington, D.C. Dibby, John, so we can quiz you later on the truth about Jim, would you please stand for just a moment and be recognized? Right here, Dibby and John. Because there's no one in this room who can't read between the lines, in one way or another we all do this for a living, I trust you'll understand that my mini roast of this man happened because I know of no other way to adequately express my honest and earnest regard for his talent and his intellect, and my profound appreciation for his consistent caring, compassionate collegiality, and friendship over these past 4 decades, in good times and otherwise. I stand on behalf of the Academy, Jim, in expressing our pride and gratefulness for your leadership, and I accept with pleasure the honor you've bestowed today in allowing me to present you to your colleagues and friends. Ladies and gentlemen, my dear friend and our president, Jim Oldham.
Oh, I knew it was going to be bad. And I'm trying to imagine how to segue from Rich's introduction to the title of my talk, which is Historical Perspectives on the Judicial Enforcement of Arbitration Agreements. But we'll do the best we can. At any rate, thank you, Rich. I knew I was going to get roasted somehow, and I've been in some fear and trembling, but here we go. He's a great friend, and I'm delighted to have his introduction. Also delighted by his recognition of my wife, Dibby, who has just been a great help with my other life as an arbitrator across the years and with many of the arrangements for this meeting. Oh, I'm sorry. That's a lot better, I can tell. I was complimenting my wife on all that she's done to be supportive of my arbitration career as well as helping with this meeting. I'm delighted that my brothers are here and their wives. Thank you both for coming. As Rich said, my twin brother is a psychiatrist, and he has explained that he became that because I beat up on him so much growing up. And I was the elder. I am older by 13 minutes. Our other brother was a surgeon on the Duke Medical Faculty during his career. So with a psychiatrist and a surgeon, I guess I figured we needed a lawyer, so that became my career. All right, let me be serious and talk about this subject, which is much involved in many of our lives as arbitrators, as well as the advocates in the room. In the 1994 meeting of the Academy of Arbitrators in Minneapolis, I gave a paper entitled "On the Constancy and Pedigree of the Arbitrator's Heritage." Now, 20 years later, I return to the past in order to say more about how arbitration was understood and practiced in the founding era of this country, and how the arbitration process interacted with the courts. So, in a moment of inspired creativity, I said to my wife, Dibby, I told her that one of my central themes was going to be to quarrel with a mid-19th century opinion by a justice of the Supreme Court, Justice Joseph Story. And I said to her, I could call this paper Story Time. And her reaction was essentially a Bronx cheer to that. But then I told Ted St. Antoine the same thing, and Ted rather much liked that. So I figure a little sophomoric humor is not a bad thing. Before reaching Justice Story's opinion, though, let me begin with the Federal Arbitration Act of 1924. That statute was only of passing interest to the labor management community for more than half a century because of the language in Section 1 that exempted contracts of employment of seamen, railroad employees, and other workers engaged in interstate commerce. This meant it was supposed that the FAA was wholly inapplicable to collective bargaining contracts, but in 2001, in a case brought by Circuit City Stores, the Supreme Court explained, in an opinion by Mr. Justice Kennedy, that everyone had misunderstood the employment exemption to the FAA, and in fact, Congress had only intended to exempt employment contracts for workers in the transportation industry, whoever exactly those employees might be. And since that decision, the FAA has come alive for labor advocates and arbitrators. But already I digress. Let's return to 1924. What was the point of the Federal Arbitration Act? The 1924 House report on the bill that became the FAA, included the following. The need for the law arises from an anachronism of our American law. Some centuries ago, because of the jealousy of the English courts for their own jurisdiction, they refused to enforce specific agreements to arbitrate upon the grounds that the courts were thereby ousted from their jurisdiction. This jealousy survived for so long a period that the principle became firmly embedded in the English common law and was adopted with it by the American courts. The courts have felt that the precedent was too strongly fixed to be overturned without legislative enactment. That statute, in many respects, was the beginning of the labor management field that many of us, perhaps most of us, have grown up studying and practicing. All right, now let me come to Joseph Story. Story was appointed to the Supreme Court by President James Madison in 1812 at the precocious age of 32. This is not the occasion to summarize his remarkable career or to marvel at his astonishing scholarly productivity. For purposes of this talk, I want to discuss an opinion he delivered in September 1845, only a few months before his death. The case was Toby against Bristol, and at issue was whether an arbitration agreement could be specifically enforced in court. Justice Story said, "No case has been cited by counsel or has fallen within the scope of my researches in which an agreement to refer a claim to arbitration has ever been specifically enforced in equity." He added that so far as the authorities go, they are altogether the other way, and the only authorities he cited were English cases. He recognized that arbitration had come into favor in commercial nations, but he said that the judicial enforcement of arbitration agreements occurred only pursuant to legislation that equipped arbitrators with all the powers that judges would have had, and that arbitration decisions could always be appealed to the courts. He thought the limited experience in America with compulsory arbitration had been unimpressive. Also, and here's the statement that caught my attention, he said, "At all events, it cannot be correctly said that public policy in our age generally favors or encourages arbitrations, which are to be final and conclusive to an extent beyond that which belongs to the ordinary operations of the common law." Now, without meaning to sully that great man's reputation, not that anything I might say could possibly do so, Justice Story's views on arbitration in America in his time were, in my opinion, mistaken. The practice of arbitration in the late 18th and early 19th century United States was, in fact, extensive, even robust, as I will shortly explain. But to stay with my topic, historical perspectives, what happened in the 18th and 19th centuries to create this anachronism that the Federal Arbitration Act was enacted to overcome? In 1743, in an English case before the Court of King's Bench, an insurance case involving a policy with an arbitration clause, that court observed that the agreement of the parties cannot oust this court. Thus, the court had jurisdiction to proceed even though no arbitration had been attempted. This expression, that an agreement to arbitrate by private parties could not oust the courts of jurisdiction, caught on in England and was repeated in subsequent cases and traveled to America. That was the mistaken notion that the Federal Arbitration Act was designed to overcome. But because of the employment contract exception in Section 1 of the Act, there was a gap of 22 years before Congress made clear in Section 301 of the Taft-Hartley Act that collective bargaining agreements, including arbitration provisions, were specifically enforceable in federal court. Well, reverting to the historical perspective, I want to explain why Justice Story was mistaken in the observation that I quoted a moment ago. The extent to which arbitration had developed in England by the year that he spoke in the middle of the 19th century is amply demonstrated by the publication in London in 1849 by Francis Russell of an exhaustive 927-page treatise titled A Treatise on the Power and Duty of an Arbitrator and the Law of Submissions and Awards. In 1872, only 2 decades later, a comparable tome was published in the United States, though only 2/3 as long, called The Law of Arbitration and Award, published by John Morse, 670 pages. In his preface, Morse observed that the tendency among businessmen to avoid the public tribunals and to settle their disputes by arbitration before individuals of their own choosing is growing stronger year by year. Yet, he said, no work on arbitration and award has ever been prepared in the United States. He acknowledged that he had made free use of the fruits of Mr. Russell's labor, but he had also searched through thousands of volumes of United States reports and had used all the means at his disposal for rendering his research exhaustive. Standing alone, Morse's 670-page treatise surely suggests that even when Justice Story spoke in 1845, the process of arbitration was well known and actively practiced. And indeed, this was true during the founding era of this country, as I will shortly demonstrate. Before doing so, it is necessary, however, to venture briefly into the law that would have been known to the founding fathers, the law once described by Justice Story as, quote, the grand reservoir of our jurisprudence, the common law of 18th century England. So, let us take a long temporal stride back to the mid-1690s. At that time in London, the Board of Trade was concerned about how costly and time-consuming commercial litigation had become and what a clog this was on beneficial mercantile activity. Thus, the board assigned one of its 5 members to draw up a scheme of some method of determining differences between merchants by arbitrators that might be decisive without appeal. The member who got that assignment, as it happens, was John Locke. Locke was not a friend to the legal profession. He divided people into 2 categories, those who contribute to trade and those who hinder trade. And as an example of those who hinder trade, he referred to multitudes of lawyers. Locke, however, understood the arbitration process. Even in his time, it was open to the common law courts to refer a case to arbitration when the facts seemed to call for it. This might occur, for example, when a dispute arose over a construction contract, and the case could be referred to an architect or an engineer to arbitrate the disagreement in a final and binding way. This was done by writing out the agreement and entering it in the judicial records as a court order. Thus, if either party thereafter refused to honor the agreement, that party could be held in contempt of court. John Locke was familiar with this process, and he understood that the key to effective enforcement of arbitration agreements would be the penalty that would attach for not honoring such an agreement. He perceived that the threat of being arrested and imprisoned for contempt of court would provide a strong incentive to parties to arbitration agreements to honor those agreements. Thus, he recommended that the Board of Trade petition Parliament to enact a statute that would make the contempt power of the common law courts available to private parties, even when no actual lawsuit had been commenced. And this is exactly what happened. Parliament passed a statute in 1698 that expressly authorized private parties who wanted to arbitrate their differences to file an affidavit to that effect, laying out their agreement and its terms, and have that agreement entered in the court's order books, subject to all the penalties of contemning a rule of court, as if a suitor or defendant in such court. So to be clear, Parliament in 1698 gave legislative approval to a creative but curious procedure for make-believe lawsuits. And here we are in story time again. No actual case would have been commenced in court, but the parties' agreement to arbitrate would be entered in the court's order books with a caption that looked exactly like a lawsuit, solely for the purpose of making the contempt power of the common law courts available for enforcement purposes. Well, what, you may be asking, is the connection between this 17th century English background and the story I am telling about Justice Story? Well, you remember that Story said that whenever arbitration was compulsory in America, it was pursuant to legislation that equipped arbitrators with all the powers necessary for effective decision-making, and there was always an appeal possibility. Neither of these features was included in the John Locke statute, and after all, that statute was designed to ensure finality, agreements that would be decisive in arbitration without appeal. So, we come to the fundamental question that has not been addressed so far, and that is this: to what extent did the John Locke statute travel to America? Recently, a research fellow and I at Georgetown investigated that question. We discovered that what we can for shorthand call the John Locke statute, that such statutes were enacted in at least 22 American states and territories in the late 18th and early 19th centuries. When Justice Story delivered his opinion in the Toby case in 1845, there were 27 states in the Union. Thus, 80% of those states, 22 of the 27, had copies or close approximations of the 1698 John Locke statute. And I give some examples of this in connection with the states of Virginia and Pennsylvania, but in the interest of time, I will skip past those for the moment. They will be in the proceedings eventually, where the full text of the paper will appear. So, those of us who serve as arbitrators in labor cases are often conscious of our remedial limitations. We don't have carte blanche to order punitive damages. We almost never do that. But we can order specific enforcement of the agreement through some of our remedies, the typical back pay award or the reinstatement. And we also can order affirmative acts in some measure. There's an interesting chapter of this in the state of Pennsylvania. Pennsylvania had its first John Locke statute in 1705, only 7 years after Parliament's Act. And it was very narrow. It applied only to accounting disputes, and it was called a Defalcation Act. And it was only intended to apply to those states. Yet, Across the 18th century, the Supreme Court of Pennsylvania and the lower courts themselves realized that this method was so effective that by judicial fiat, the courts simply applied it to all kinds of disputes, and any kind of dispute in Pennsylvania could be submitted to arbitration under the same formula, even though there was no legislative authorization to do that. That legislative authorization in Pennsylvania came finally in 1805. Okay, I want to come now to the last section of this paper having to do with the Founding Fathers. From collected papers that have been transcribed and are now in print, it's evident that the Founding Fathers were completely familiar with the arbitration process. This can be seen, for example, in the collected papers of John Adams, Alexander Hamilton, Andrew Jackson, John Marshall, Robert Morris, Daniel Webster. In the printed record, Alexander Hamilton, Andrew Jackson, and John Marshall are shown serving both as counsel and as party arbitrators. Robert Morris, as Superintendent of Finance for the United States, was extensively involved with arbitration procedures, though because of his public office he insisted on transparency, refusing to participate in arbitration proceedings that were to be kept confidential. John Adams and Samuel Webster are not shown in the printed papers as arbitrators, but both participated in arbitration proceedings as counsel. Both men appeared to have been fiercely scrappy litigators with little appreciation for the classic advantages that we know, such as brevity and economy. An example is a seemingly simple case of Duane against Gage, with John Adams representing the plaintiff from 1766 to 1769. This case will be appreciated by Arnie Zach. I know Arnie's here. Where are you, Arnie? Arnie's a lifelong Cape Codder, and this was a suit between two Cape Cod whalers. And they were quarreling over a captured whale. Captain Duane sued Captain Gage for what Duane claimed was his portion of a captured whale. The whale was first hit by an iron from Duane's boat, but Gage later struck the whale with his line, and the line from Duane's boat came free. Duane claimed capture rights, and Adams called witnesses to testify to the customary law of whaling, arguing that a boat was considered in possession of a whale when it was fast to it, that is, when its iron was still seated in the whale and the line was still in the boat's control. The outcome of the case is not indicated in the Adams papers, but amazingly, the arbitration hearing took 6 days, and even more amazing, at least 74 witnesses were called. 34 for Duane and 40 for Gage. According to the papers of Daniel Webster, when Webster practiced in Portsmouth, New Hampshire, and the editors write, arbitration and reference then were the principal methods of extrajudicial settlement resorted to by merchants and other litigants, and debtors often chose arbitration because it eliminated the need to hire a lawyer. Webster's distaste for arbitration is revealed in a book review that he published of an 1806 volume of case reports. And after speaking of the excellent contribution of precedents to the judicial system, because they prevent the substitution of personal opinions for the doctrines of law, Webster stated, "No man in this age contends for the literal constructions and black-lettered niceties of the ancient gown men, nor will a wise man push to the other extreme and overwhelm all certainty and all rule in the chaos of arbitration principles." Well, a final Founding Fathers reference is due to Thomas Jefferson. Along with other leading Virginians, Jefferson worked to revise the laws of Virginia from 1776 to 1786. One of the bills that passed in 1789 was Virginia's version of the John Locke statute. That statute gave legislative approval to references to arbitration, specifying that the arbitration agreement could be entered of record as a rule of court, and any party refusing or neglecting to comply could be proceeded against for contemning the rule. Also, anticipating provisions to come in the Federal Arbitration Act, the statute provided that an arbitration award pursuant to the procedures outlined would not be upheld if sworn proof were demonstrated of some misbehavior in the arbitrators, or that the award was procured by undue means, or unless the award on the face of it appeared contrary to law. Jefferson's connection with the arbitration process continued for decades, including disputes that arose in the construction of buildings at the University of Virginia. One worker, a carpenter and joiner from Philadelphia, appears frequently in correspondence with Jefferson, dealing with work performed at Monticello in the early 1800s and later in the 1820s at the University of Virginia in Charlottesville. This fellow in 1822 complained to Jefferson that the proctor of the University of Virginia was refusing to pay his bills. And in one responsive letter, Jefferson said, "I should think both of you would prefer arbitration to law, but in this you must choose for yourselves." Later, this carpenter, and by the way, I am not making this up, the carpenter's name was James Oldham, spelled exactly like mine. James Oldham, the carpenter, wrote a long letter to the University of Virginia Board of Visitors itemizing his complaints, and he explained that in late 1821 and 1822 he had agreed with the proctor that they would settle their difficulties by two arbitrators, one to be chosen by each of them, but the proctor retracted his agreement to arbitrate, and Oldham elected not to incur the cost of a lawsuit and embroil himself and the university in litigation, because he was persuaded that the Board of Visitors would agree with him that the submission of disputes of this character to arbitration is not only the most equitable, but the most eligible method of deciding them. He stated that he had also consulted the rector of the university about his complaints, and the rector appeared to be willing to submit a portion of Oldham's bills to arbitration, but the rector thought that Oldham ought to consent that those arbitrators should be farmers and not carpenters. Oldham responded that if farmers could be procured who were much experienced in house joining, he would be willing to submit to their accord, but he doubted that farmers would be so well qualified. Well, the observation about farmers as arbitrators brings me back finally to Justice Joseph Story. In the Toby decision, Justice Story said, "We all know that arbitrators at the common law are not ordinarily well enough acquainted with the principles of law or equity to administer either effectually in complicated cases, and hence it has often been said that judgment of arbitrators is but rusticum judicium, rough adjudication, rough justice." I'm sure many of us feel that way when caught in the ever-expanding tangle of external law. But even here, I part company with Justice Story at least a bit. In the two states for which I have done archival research, Maryland and Pennsylvania, arbitrators were often lawyers or men with expertise relevant to the subject matter under dispute. All right, coming to my conclusion. From these historical perspectives, I hope to have persuaded you that the practice of arbitration in the time of the founders was extensive, and that by the early 19th century, most states had adopted Lockean statutes that either allowed arbitration agreements to be enforced by the contempt power or allowed arbitration agreements to be executed as if they were court judgments. With regard to Justice Story's comments in the Toby case, one might wonder why the pervasiveness of the state statutes adopting the John Locke method was so obscure, even to the Supreme Court in 1845, or to the early treatise writers on arbitration. And I don't have a clear answer to that, but one possibility is simple. That is, that the enforcement proceedings simply did not appear in the printed records of the time. So let me close with a final scrap of history from the early Republic, a fanciful gem of wishful thinking. This was a letter sent on June 29, 1789, by a resident of Charles County, Maryland, a man named Zephaniah Turner, to President George Washington. Some of you have heard me quote this before, but it is worth repeating. Zephaniah Turner wrote the following to George Washington. Sir, I have many friends among the gentlemen of the bar, and I mean not to hurt their interests or feelings, unless a wish for the welfare of my native land might happen to do this. Our laws are too numerous. Is it not possible that an alteration could be made for the benefit of the public? Could it not be possible to curtail the number of lawyers in the different states? Suppose each state was to have but 2 lawyers, to be paid liberally without fee or reward except the salaries paid by each state, and that when a real dispute subsisted between plaintiff and defendant, a reference to arbitration could be proposed, and arbitrators be indifferently chosen by both parties, whose determination shall be final. I would not mean to discourage the study of law, but I really find that the multiplicity of students in that branch in this state has been an inconvenience to the sons of reputable parents, and the more so to the parents themselves. Well, in retrospect, this burst of imagination is, at the least, a colorful illustration of the popular awareness and appreciation of the positive role played by arbitrators in resolving disputes among the citizens of the early republic. So, ours is an honorable profession. It has a rich history. It's a profession that has made and continues to make substantial contributions to the civil governance of this country. I am proud to belong to this honorable profession and to this excellent academy, and it has been a privilege to have served as your president for this year. Thank you very much.
For those of you who didn't know it, we are adjourned.